Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this set of videos we're going to be discussing about the Child Status Protection Act, otherwise known as the CSPA. This particular act was put into effect primarily because petitions were taking years and years to become current. And what would happen is when a petition began, a child might be 6 years old, and when a petition became current, the child would be 23 years old and or more. And the way that the law normally works, at least prior to the CSPA, is that once the child reached the age of 21, he or she would then age out from the petition, meaning that they would no longer qualify as a derivative. The parents would be able to immigrate to the United States, but they'd have to leave the son or daughter behind. They'd have to be re-petitioned again for another 12, 15 years, give or take. And, essentially by the time they got into the United States, they'd be 30, 40, even older years old, before they'd be able to immigrate in. So the Child Status Protection Act, the CSPA, has different provisions to allow, under certain circumstances, the age of the child to freeze, meaning for immigration purposes, the child is, so old, even though in reality the child may be older than 21. So the issue then becomes, under what circumstances is the age going to freeze, and under what circumstances will the CSPA be appropriate to use? And we will discuss those in the coming videos. Okay, more momentarily.